you're trying to find that. All right. You need to look at least 5 places a week. All right. Step in front of the clerk. She'll give you a reset notice. Good morning. Are you Sean Dage? And this is cause number 24 DCCR 2353. Mr. Dage was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has your honor.
Yes, Judge.
Are there any additions or corrections?
None from defense.
No, that's that.
What? So I guess what I'm trying to figure out is the additional case. Was there an assault
Your honor,
filed also as part of this?
It was not filed, Judge.
it was refused, your honor, according to the report, and it's hotly contested on the defense.
Okay. Okay. So that's the burglary that was refused.
Yes, your honor. And I know there's a recitation of the facts but those are hotly contested.
Okay. All right. Well, then, I mean, obviously the criminal history gives me a whole lot of concern. And whatever went on that night shouldn't have happened. So I mean, I don't understand. In 2019, there was an evading arrest or detention with previous convictions, and he got a 4-year TDC on it. So I guess
The initial offer was for time in this case, Judge, after lengthy discussions with Mr. Lane and the fact that that underlying case was refused. I came down with a probation. We will respect your opinion on this.
My only brief retort, your honor, is these are evading on foot.
but you don't get to keep doing it and then get rewarded for continued bad behavior, right? You don't go to prison for something typically and then get a better deal the next time you do the same thing. You see how that doesn't make sense to me and to most people?
And your honor, brief argument, we are asking the court to follow the agreement. Mr. Diggs does have a lifestyle and a plan, work and paying child support, a life now that does not seem like anything that the court is reviewing now. The court does have the mechanism, of course, to really put them in jail for a long time. The moral recognition therapy could work, any other type programs the court may have. We believe he can do it.
I mean, and so I guess the case is from 2024. Have you been out since then on bond? And I got the letter, and I'll take judicial notice to the court's file. It does include a letter that was sent over by your attorney from Mr. Peterson, who I used to work with and trust and value his opinion greatly. And he sent a very supportive letter about you working in that office building and that everyone valued you there. So obviously, maybe you finally figured it out because the criminal history doesn't look like it, but you're older now. A lot of this was when you were younger, but you got to realize that it doesn't matter if you get scared. It doesn't matter what you're doing. If a cop says they want to talk to you for any reason, you would have been talked to them and not been here in felony court if you hadn't ran, So being scared isn't an excuse anymore. Because if something happens, if I go follow this probation, and something happens while you're on this probation, you're looking at the 10-year sentence that you've already agreed to. No negotiations, 10 years in prison. Do you understand? All right, then I'm going to find that you entered your previous plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. Also find the prior offenses, convictions true that you pled true to. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. The order to pay the
6 years, Judge. It's 10
sorry.
probated for 6.
Okay, sorry, the PSI has it as 10.
That's right.
So that would have been one of those corrections.
Yes, I
That's
apologize,
for-
Ron.
6 years probation. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. It sounds like this shouldn't be a problem for you. It's just following the rules, go into probation, do your community service, keep working, and you should be fine. You'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and your probation can be revoked and you would be facing that 10-year sentence that you've agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lane. If you'll just have a seat here in the courtroom, watch for probation. She's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir.
Thank you.
Would you turn that video down and see if maybe it'll kick on?
Terrence Harrington is arrived. He was earlier on the
Okay,
docket.
thank you.
ma'am.
Good morning. Are you Stephen Gray?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Gray, in cause number 26 DCCR 0294, you're charged with the third-degree felony offense of driving while intoxicated, third or more, from December 27th of 2025. The indictment alleges you were previously convicted of driving while intoxicated June 27th of 2012, and after that was final, you were convicted of driving while intoxicated March 7th of 2014. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they charged you with?
Yes, Your Honor.
And are those two prior convictions true?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, I did.
Do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. Y'all mark.
$1,000 fine.
Okay.
Sorry, and I didn't put 10 days.
That's a condition that's required. So it looks like the fine would be $1,000. You understand a condition of getting probation is also that you would have to serve 10 days in jail
Yes, Your Honor.
and follow all of the other rules and conditions of probation.
Yes, Your Honor.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Gray is not competent?
Negative.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. But what I'm going to do is reset your case for about 30, well, actually, it's to be a little longer than that, so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today. And she's sitting at that desk right over there. All right, we'll see you back at sentencing. Junius Vital.
Your Honor, that's Ms. French's case, and it's an unagreed plea. I don't know if you want to wait on her. or-
Okay, is she come?
It's an initial.
Oh, y'all might not even have.
Here, I've got the information from Ashley, so you'll know if you want.
No. Very good.
You can keep it so you know.
All right, sir, are you Christopher Hunt?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Your Honor.
Mr. Hunt, in cause number 25 DCCR 1766, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault. So is it assault family violence?
No, it's just Class A assault, not family violence.
Okay. And that's from September 28th of 2025. And how do you plead to that charge?
Not guilty?
No.
No, guilty?
Here's the,
Did you do it or not?
yeah, it's okay. So are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I did.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Do you understand? I'm assuming one of those would also be that you have no contact or communication at all with David LeBlanc. Do you understand? That's obviously in person, but that also means any type of communication. You can't send messages or through social media or anything.
Okay.
That'll be a part of your probation. You understand?
That will?
Yes.
Okay.
What? All right. So, are you a U.S. citizen?
Yes.
So what's the relationship with Mr. LeBlanc?
He was a friend of my mom's.
Okay.
He was staying at my house.
All right. So obviously that's no longer acceptable. You cannot be around him at all, period.
We'll make sure that happens.
Okay. State tenders number 1.
No objection?
It's admitted. Any evidence that Mr. Hunt is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that and follow all of those rules, at the end of your probation period, the case will actually be dismissed if you're successful. So you won't have the conviction on your record.
Okay.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You would be found guilty of the offense and you could be sent to the Jefferson County Jail for up to 1 year. Do you understand?
Yes, ma'am.
All right, if you'll just have a seat here in the courtroom, probation's sitting at that desk right behind you. She's going to call you up to her desk when she's ready to go over your paperwork. Just wait for her to call you up. Good morning. Are you Rakeem Allen? Speak up, please.
Yes, ma'am.
And this is cause numbers 25 DCCR 1163, 1164, and 1697. Mr. Allen is charged with evading arrest or detention with the use of a vehicle and 2 cases of possession of a controlled substance. Mr. Burbank, what is the announcement?
Your Honor, I've been talking to Miss Chase about this. Mr. Allen and I had a communication problem in the last couple of weeks. It looks like we have corrected it. It had nothing to do with witnesses, but actually getting into contact. I would ask for one more reset, Judge, to see if we can't, the office 10 years or 12-year cap. And I was talking to Miss Mofino about another option.
Mr. Allen, do you have the drug patch? I don't see the most recent results, and so I'm going to have you have a seat in the jury box and let's get a test this morning just because I don't have the most recent results. The last one I have was positive. That's fine.
We've got probably 10 positives on him ever since he first got his cases. He keeps blocking out. So I was going to ask you to test it. Thank you.
Oh, she must be in the electric.
Oh, yeah. I remember this. That's unfortunate. Okay. Tiana Hughes, Mr. Burbank.
Yeah, this is.
Good morning, ma'am. Are you Tiana Hughes? Yes. And this is 25 DCCR 1058. Ms. Hughes is charged with credit or debit card abuse. And Mr. Burbank, what is the
I
announcement?
hate to tell you, just one, a reset, this will be dispositive, needs to get her money together. She had some problems with the bank and some other stuff, rough with straightening out. But she has corrected that. So if I just get a normal reset, it should be finished next time.
Okay. So any issues?
No, Your Honor.
All right, we'll just do a normal reset, Ms. Hughes. Make sure you stay in touch with Mr. Burbank. He'll let you know when you need to be back for that next court date. Okay, you're free to go. Cody Litchfield. Good morning, you're Cody Litchfield. And this is cause number 26 DCCR 0646. Mr. Litchfield is charged with attempt to commit arson. And Mr. Burbank, what is the announcement?
I am not finished with discovery. I'm trying to get some video of this through the fire department in the county. And so that's where I'm at.
Any issues, Mr. Nichols?
No, Your Honor.
All right, we'll just do a normal reset. Mr. Litchfield, stay in touch with Mr. Burbank. He'll let you know when you need to be back.
You're free to go.
You're free to go. And Crystal Robertson. And then don't leave after you're done when I've mentioned something. This is Mr. Coleman's case on a Crystal Robertson. Good morning, ma'am. You're Crystal Robertson.
Yes, ma'am.
And this is 25 DCCR 1526. Ms. Robertson is charged with forgery of a governmental instrument. And what is the announcement?
Your Honor, she is in between jobs. What I mean by that is she has a job, she's just gotten a better job, and there is a bonus. She's going to a government entity. This is a case of restitution and then solution for final disposition. So I would ask Judge, and that was the intent of the prosecutor and myself, so that we can get this by her so that she doesn't have any felony.
When do you anticipate?
July?
Okay, so we'll just do a normal reset.
Yeah, sure.
And so, Ms. Robertson, I'm going to reset your case normal about 30 days or so. Stay in touch with Mr. Burbank. He'll let you know when you need to be back. All right.
Okay. I think that's all.
All right, we're back on the record in cause number 25 DCCR 1374. Mr. Vitale tested positive for cocaine. So, Mr. Vitale, you've been to ISF twice while you're on parole. So parole's given you 2 opportunities not to revoke your parole. And you get off parole and here you are with another felony and you're using cocaine again.
You need some help, Mr. Ma'am.
I'm sorry?
I just need help.
Well, you've gotten the help and you're looking at a cap of 4 and I was well on my way to giving you an opportunity. But there's no way I can do that with your criminal history and the fact that you've been given, because if you hadn't been to ISF, I'd say, okay, maybe I'll send you to ISF, but you've been twice in the last 5 years. All right, at this time, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of failure to comply with sex offender registration requirements. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Park. All right, good luck to you, sir. You can go back with the bailiff. Mr. Pageant on Catherine Bautista.
I was when you first.
Okay.
So,
Good morning, you're Catherine Bautista. And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Bautista, in cause number 25 DCCR 1608, you're charged with the state jail felony offense of publishing or threatening to publish intimate visual material from September 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Paget?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in state jail prison, but that would be probated. You'd be on probation for 3 years. You would be ordered to pay a $300 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
No objections to stage one, Your Honor.
It's admitted. Is there any evidence that Ms. Batista is not competent?
None, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty.
There's one, she had a case 10 years ago that ended as a state jail revocation, but that's it, Judge. I don't see any reason.
Not to waive.
Not to waive.
All right, so Ms. Batista, I'm going to waive the pre-sentence report. Find sufficient evidence to find you guilty, and at this time, find you guilty of publishing or threatening to publish intimate visual material. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but that will be probated. You'll be on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, then this is a great opportunity because you'll be able to serve that 2-year sentence while you're out on probation.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you'll be facing that 2-year sentence that you've agreed to. Do you understand?
Yes, ma'am.
And I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. It's printing, I think. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Padgett.
Yes, ma'am.
So if you'll just have a seat here in the courtroom, probation is sitting at that desk right behind you. She's going to call you up to her desk when she's ready to go over your paperwork. So watch for her to call your name.
Okay.
All right. And if you'll make sure and send that attachment over.
No.
Mr. Allen tested negative. So obviously that's good. You need to continue to test negative. If there's a positive drug screen that comes back, those bonds are going to be high enough to where you can't make them. All right. So we've gone through this too much, but I don't have any, but it looks like you've finally gotten the message that you can't use while you're out on bond. So we need to reset then,
Yeah, sure.
just a normal reset. All right, stay in touch with Mr. Burbank, talk to him well before that next court date so that we'll be prepared on the next court dates for you guys to make an announcement, okay? All right, free to go.
That makes sense.
Yes, thank you. Good morning. Are you Miguel Martinez? And this is 25 DCCR 0584. Mr. Martinez is charged with aggravated sexual assault of a child. This was the last reset. So what is the announcement?
Judge, as you know, I've been in trial the last several weeks. I got an offer toward the end of last week from Ms. French. It's a pretty daunting offer. We are not intending on going to trial. What we're asking is 2 weeks to allow him to get his sort of affairs in order, to explain what may be the parameters to his family, all of those things. But we're not going to come in and announce trial after that.
Okay, so
it's going to be some kind of resolution. I just don't know if we're going to accept this deal or potentially plead open to the court.
But it'll be a plea in 2 weeks.
I anticipate it will, Judge.
All right, we'll reset it for a plea in 2 weeks. Mr. Martinez, make sure you stay in touch with Mr. Gertz, and then we'll get it taken care of at the next court date.
We already had the
I don't have it on the docket.
we already had the conversation with him about. Okay.
Yeah, I wouldn't think that.
Shut up, sir.
Yeah, that.
Shut up.
Good morning. Are you Marco Morales? And this is 26 DCCR 0160. Mr. Morales is charged with evading arrest or detention with the use of a vehicle. Mr. Gilthorpe, what is the announcement?
Judge, if I could have one reset to negotiate with Ms. Bolfino, she has already extended an offer. But she and I had a discussion, we were just seeing if something else would work.
Okay, so
I anticipate a plea.
I'll reset one more time to give you some time to get that taken care of. Mr. Morales, make sure you stay in touch with Mr. Gilthorpe so that you know what's going on, and we'll get an announcement at the next court date. Okay, you're free to go. Yes, sir. Kristen Bell is Miss it's Miss French's case. Good morning, ma'am. Are you Kristen Bell?
Yes.
And this is cause number 25 DCCR 1812. Ms. Bell's charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, this is our first setting. I have originally received a no offer from Ms. French that she wanted to get more information on CPS records. And then she sent me a revised offer Friday. and I
Okay.
haven't had a chance to move forward with Ms. Bell.
All right, so we'll just do, any issues that you see, Mr. Smith? We'll just do a normal reset, Ms. Bell. Make sure you make an appointment, go visit with Ms. Holmes before that next court date so that you can, be prepared for an announcement at that time. All right, you're free to go.
Thank you.
Good morning. Are you Kenneth Cormier? And this is 25 DCCR 1113. Mr. Cormier is charged with obstruction or retaliation. What is the announcement?
Yeah, and I know this case is getting a little old.
It's getting way old.
Yes, ma'am. If we could get one more, we're close. There was some mitigating factors I wanted to give as far as employment and everything for Mr. Cormier.
Here's what we're gonna do. I'm gonna reset it 2 weeks. So whatever needs to take place in
Yes,
those
ma'am.
2 weeks, this will be the final reset. Mr. Cormier, if there's any information that you have that Ms. Holmes needs, you need to get it to her quickly so she can get it to Mr. Coleman so that we will get an announcement one way or the other the next court.
Yes, ma'am.
All right, thank you.
Okay.
You're free to go, sir.
In this courtroom session, the judge delivered a clear message. Accountability comes before excuses. One defendant earned probation after convincing the court he had finally turned his life around through steady work and personal responsibility, but with one strict warning. A single violation would activate a lengthy prison sentence. Others were not as fortunate. A repeat offender who continued using cocaine after multiple chances lost the opportunity for leniency and was sentenced to 4 years in prison, proving that rehabilitation only works when the defendant is willing to change. Throughout the hearing, the judge carefully balanced compassion with public safety, approving probation for defendants who accepted responsibility while making it clear that repeat criminal behavior, failed drug tests, and broken trust would carry serious consequences. From DWI and assault cases to drug offenses and probation decisions, every ruling reinforced the same principle. The justice system can offer second chances, but those opportunities come with strict conditions. In the courtroom, your future isn't determined by promises. It's determined by your actions.